Live.
All right. Good afternoon. This is the House Judiciary Committee. It is January the 27th, 2022. Welcome to our hearing today, where we are going to have hearings on 7 bills, including 2 to begin with Delegate Atterbury, the former vice chair, now the chair of Ways and Means, and all fancy. And so we are going to hear Chair Atterbury's bills, House Bill 104 and 83 first. We're then going to hear Delegate Crutchfield's bill 153, then 161 for Delegate Shetty, 110 from Delegate Shetty and Delegate Pippy, 121 from Delegate Cardin, and 148 from Delegate Bartlett. I will inform everybody watching that we are going to stop at 2 o'clock. We're going to have to go back to the floor, and then we're going to do the work on the floor, and then we will come back between 15 and 30 minutes after the end of the floor session, which you can view at the Maryland General Assembly's website, to begin bill hearings again. We apologize to any of the witnesses. I'm sorry that this is going to make it a little more confusing, but this is the best that we can do. So we are going to go ahead and get started here and try and cover as much ground as we can between now and 2 o'clock. So with that, Madam Chair, the Chair of Ways and Means, here with us today.
Thank you, Mr. Chair. Thank you. It's good to see everybody. I miss you guys. So I'm here to present and ask for a favorable report on House Bill 140. And this is a repeat bill because the Senate did not pass it. You all passed it. The House passed it 120-13 during last session. And this committee passed it 15-5. And this is a bill involving custody that implements recommendations of a work group that was in 2020 that was formed to study child custody court proceedings involving child abuse and domestic violence allegations. And the final report is on the website, and it was in 2020. I saw there are a lot of favorable with amendments. And so the only thing I'm going to say, because I'm going to be very brief, the bill is very straightforward. I suspect, I have not seen the testimony, but the issue in question came up last year, is on the final page of the bill in section B. So section 9-105, letter B. Where it states any reasonable effort to protect a child or a party to a custody or visitation order from the other party is not considered an unjustifiable denial or interference with visitation of that order. And so I know some folks have an issue with that, because the argument can be made that anybody can say that somebody is making up allegations. But what I would say to that is a judge has to determine whether or not the denial of the visitation was justifiable or not. And then in the normal course, if the judge finds that the denial was unjustified, the judge can do many things, including attorney's fees. So with that, Mr. Chair, Mr. Vice Chair, and committee, I would ask for a favorable report. Thank you.
Thank you very much. I did not mention this is a bill that is basically, well, it is a reintroduction of something we did last year. So the people who are introducing, the members introducing the bill gets 2 minutes. Witnesses get 1 minute to speak. So this is the 2-in-1 rule for this bill, and I think it's pretty much all of the bills today. So we'll repeat that a couple more times. Let's go ahead and hear from those people who are favorable and favorable with amendments, so that we can kind of then take questions after that, maybe streamline this a little bit. So we'll hear from Paul Griffin, Michelle Smith, and Lori Ruth. Paul Griffin is favorable. Michelle Smith and Lori Ruth are both favorable with amendments. So we'll hear from them, and they are being admitted into the room right now. And if I talk a little bit longer, then I can find Paul Griffin.
Yes, sir.
All right, Mr. Griffin, for 1 minute, please.
Thank you, Mr. Chairman. I'll make it quick, so I have a minute. I think there's no controversy on the first section, so I'll talk on the second section about the reasonableness. I heard some of the complaints in the criticism in the other chamber that this was either redundant. This was redundant and dangerous. I'm not sure it can be both. It could be possibly redundant, or it could be dangerous, but I don't think it can be both at the same time. But I think this is some necessary language. It's going to give guidance to parents and to the court. And it does not change the judge's responsibility or authority. A parent can't simply wave a card and said, oh, I'm citing 901-5. You can't do anything. The judge still has to find the actions are reasonable. And this is a real world application. If I could just direct you to a case from 1992, Hankey versus Hankey, 94 Maryland, App 65. It was a case where mother withheld the child after the father had been criminally convicted of sexually abusing the child. And the judge was so angry the mother withheld the child, he switched custody of the father. The Court of Special Appeals reversed. And they said, quote, even if the judge were correct that Ms. Hankey was not acting in compliance with the judge's order, his primary responsibility was to protect this minor child and not to punish Ms. Hankey. Where the evidence is such that a parent is justified in believing that the other parent is sexually abusing the child, it is inconceivable that that parent will surrender the child to the abusing parent without stringent safeguards. Last sentence. The fact that the judge does not agree with the parent's fear is immaterial. This is not a case in which there's no basis for the mother's belief. So courts do need some guidance. I'm sorry?
If you could wrap it up, please, that would be fine.
I think that unfortunately, this is an obscure case. It's not citing 9105. I kind of stumbled upon it over the years. The courts need guidance like what's said in Hankey and what is said in our amendment here. We think that the fact that a parent reasonably was taking reasonable precautions to protect the child should not be a basis to, in effect, punish them under 9105. Okay. Again, the court makes the determination of reasonableness. Thank you, Mr. Chairman.
Thank you very much. We'll hear now from Michelle Smith for 1 minute, please. Michelle Smith.
Thank you, Mr. Chair. Hello, committee members. I'm Michelle Smith. I'm here on behalf of the Family and Juvenile Law Section of the Maryland State Bar Association. Based on our written testimony, the committee is already aware that we are supporting House Bill 104 with amendments, and the amendment goes to exactly what the previous speaker was saying. As practitioners, we do have concerns that the language at lines 30 through 33 on page 2 will give parents what they may consider to be a shield to withhold the child from the other parent, citing their own reasonable beliefs, which can only be determined, in our opinion, by the fact finder, which is in family law matters, a magistrate or a judicial officer. So we are concerned that this will actually confuse some pro se litigants into thinking that if they believe their actions are reasonable, that no court could overturn their own decisions.
Thank you very much. We'll hear now from Lori Ruth, please, for a minute. Lori Ruth, are you here?
Yes, I'm here. Good afternoon, Mr. Chair, Mr. Brand new Vice Chair and members of the committee. My name is Lori Ruth. I'm the legal director at the Women's Law Center of Maryland. I don't need to repeat what Ms. Smith said. I just want to give the one example of what we have seen frequently in the past 2 years, which is one parent who does not believe in vaccinating their child and one parent who does believe in vaccinating their child. They both believe that they are behaving reasonably. And so if they withhold the child on that basis, whichever side they're on, the language in 9105 as drafted gives the impression that they get to decide reasonableness. And that's not how courts work. As all of you who are lawyers and probably everybody on this committee knows, the judge decides reasonableness, the court decides reasonableness. And this language, I believe, is redundant to the lines 20 and 21 up above, or 21 and 22, excuse me, and also potentially sends the wrong message to pro se litigants. The Women's Law Center amendment would seek to strike that language entirely. So we are favorable with amendments, and thank you very much.
All right, thank you very much. Are there questions now for this panel? These are both favorable and favorable with the amendment. So keep that in mind as you direct your questions to specific people. Delegate Erican.
Thank you, Mr. Chair. Thanks for bringing this back, Madam Chair. I appreciate this bill a lot. That was an interesting sort of comparison there. My understanding of the bill, and maybe Paul Griffin can help me figure this out, was that the parent can't just withhold custody and visitation because they don't like a decision that the parent is making about something medical. That would obviously need to go through the normal channels, but for abuse situations where the parent believes the child's life is in danger, their well-being is in danger. I'm not sure if a pretty common medical debate would be something that would trigger that part of the new language if this was to go into effect. Oh, Paul, you're muted.
I'm sorry, can you hear me now?
Yep.
I have my hand raised too. I see. I'll take that down when I'm done. It does say it has to be protecting from the other party or the other parent. And while it doesn't straight explicitly, it has to be physical harm. It's certainly implied in there. I understand the context that we're using now in COVID. I'm just not sure that a once in a century pandemic is a good basis to pass or not pass laws in this area, because we're afraid that the vaccines will be used as an excuse one way or the other. It really is designed for cases of abuse, to protect the child, which is the court's first concern, of course, and to give some protection to that parent who's taking, again, reasonable actions according to the court. The judge makes the decision. And to the extent we were to make any amendments, I would state that perhaps it would certainly be making it clear that it's the judge's decision about what is reasonable. But I don't think striking this language is going to be helpful. We cite to 9105, I cite to the Hankey case. I have judges say, well, I disagree. I disagree. There was no harm here. And that's not the point. It's the reasonableness of the person acting and their belief, which is what the Hankey case makes clear. And I think this language here helps drive that home. Both judges and parties need some guidance here. Delegate.
Yeah. So can you just walk us through like what would actually happen? So let's say, party one has a child that discloses to them that they're being abused. They withhold the next, this weekend's visitation because they're concerned. What's next? I mean, they can't just withhold it. Now, what does party two need to file, some kind of grievance that they've...
Well, often what you'll do, I mean, you'll have sometimes protective orders will be filed. We saw it. Sometimes they will report to Child Protective Services, but sometimes you have litigants who don't know what to do and they just hold the child. They just think that the court will help me. The parent who believes they're being aggrieved, who's not getting visitation, the alleged abuse of a parent, will usually file a petition for contempt and for enforcement under 9105 to have them comply with the order. And then there'll be a hearing on that matter. And I'll skip the contempt law recitation, but under the 9105, the courts can make a determination about whether the actions are reasonable. They can order makeup time. They can do attorney's fees. I've seen them go as far as flip custody on short notice.
Yeah, so this could still be, a parent who is withholding custody, if they aren't dang sure that they're in the right, they could be risking the custody agreement that they already have in place. So it's probably not something that's going to be abused.
Absolutely correct.
People ask me all the time, this is a problem in many communities where one parent is suspected of something. And I have women constantly, can I keep my child? And I'm like, you need to talk to your lawyer because you need to be dang sure that you're correct about what's happening. Otherwise, if this comes in front of a judge, you could find that you are not having your own visitation with your child.
Exactly.
So there is a risk either way.
There is. The hardest discussion we have with a parent who believes their child's being abused is telling them you need to return the child to the supposed abusive parent because you don't have enough evidence. And if you keep doing this, you're going to lose custody and you'll never be able to protect this child.
Yeah, it's the saddest thing I've ever seen.
We have.
Yeah, it's heartbreaking. Thanks for all your work on this.
Thank you, ma'am.
Are there further questions for this panel? All right, then thank you all very much for your testimony. We'll hear from those in opposition to the bill. We have Eric Smith and Vince McAvoy. If we could have them brought in, that would be great. And we'll begin with Eric Smith. We don't have Eric Smith just yet. So if we have Mr. McAvoy, Vince McAvoy. Mr. McAvoy. There's Mr. McAvoy. Mr.
Yes.
McAvoy, if you'd like to testify for 1 minute, please.
Okay, Chair, are we going to go with Eric?
I don't think we have him yet. So we're going with you until we get to Eric.
Grateful. I want to thank you, committee, for hearing me on this bill. I'm firmly against this bill. Some of the discussion in the Senate was very poignant yesterday, and it was on different sides of this issue. This bill, which should not be passed, would apply to every custody case, and it makes presumption that parents are unfit. A reminder for your committee that statewide, all domestic violence cases affect less than 3.35% of Marylanders. It's even fewer when you whittle that down for children. But how convenient it is for the domestic violence industry to come up with this bill. They suddenly forgot about ex parte filings. They forgot about bench commissioners and filing protective and peace orders. In Maryland, if there's perjury, nothing happens to, chiefly during this, mothers committing perjury. Your former colleagues, now Judge Michael Malone, and our past senator from JPR had a discussion on this. So we know this to be the case. So the issue that we want to take from this is that this is a broad branch. It would subsume the rest of the code and actually introduces a piece where you can't even prove without a preponderance, right? 50.
Mr. McAvoy,
Yes.
I need you to begin to wrap up, please.
All right, thank you, Chair. This is a poor bill. It would make unlawful violation of court orders a everyday issue. It would be denying fathers their parental rights. I urge you to vote unfavorably. Thank you for your time.
Thank you very much. Eric Smith, are you available? Are you on the line? Eric Smith.
Chair, he lost.
not-
Chair, he lost his link.
Okay. He is not in the waiting room. It was resent to him 10 minutes ago.
I understand. Thank
Are
you.
there questions for Mr. McAvoy? Seeing none, thank you all very much. That concludes the testimony on House Bill 104. We're going to go now to House Bill 83. And this again with the Chair of Ways and Means, former Vice Chair of the greatest committee ever created in the House of Delegates. Now she's chair of some other committee. But Delegate Atterbury, would you like to present House Bill 83?
Yes, thank you, Mr. Chair. And this doesn't go against my 2 minutes. I mean, you swapped me for Delegate Shoemaker. I mean, I think Ways and Means made out better. I'm just saying. And, I love you guys. They made me an offer I couldn't refuse.
Delegate Shoemaker has already made positive contributions. Don't belittle Delegate Shoemaker. Just to
I mean,
make
he's a
yourself
good
feel
country
better.
lawyer. He's a good country lawyer. I like Delegate Shoemaker. I was sad, actually, he wasn't going to be over here. But anyway.
Why don't we talk about House Bill 83 then?
Okay, I'm ready. Sorry. So House Bill 83 is absolutely not new to this committee. So my comments, I'm going to try to keep to 2 minutes. My comments are really for the new members of Judiciary. So just as history, this bill has been brought since 2016. Currently in the state of Maryland, you can get married if you're 15 and 16 and you are pregnant or have had a child and your parents say it's okay, one of your parents, or if you're 17 and it's one or the other. And what I've learned throughout this process when I learned this in 2016 is that Maryland is not unlike a lot of other, what in our mind, when we think of forced marriage, we think of another country, but it happens in Howard County, Montgomery County, and Arundel County, and it happens in our state. So bringing it up to date, we started out in the House of Delegates and the House was able to get out an 18 bright line. You can only get married if you're 18, which quite frankly would be my personal preference. But to compromise, we have worked up a bill that involves emancipation because someone might actually want to get emancipated for numerous reasons, not just to get married. And Maryland does not have an emancipation statute. So if you are emancipated under this bill, by a court, then you can go ahead and petition for marriage. This bill puts incredible parameters around emancipation. The judge has to make specific findings. An attorney has to be provided for the petitioner, so to make sure that there's no coercion. And so the last thing I'll say, since I have just 2 minutes, the last thing I'll say is since 2016, New Jersey has passed Bright Line 18. Delaware has passed Bright Line 18. New York has passed Bright Line 18. Ohio has said 17 and emancipated. Kentucky has said 17 and emancipated. And Virginia has 18 or emancipated. We are falling behind. And in Maryland, we are actually becoming a destination for older individuals to come and marry minors. Final thing, Mr. Chair, I promise, I just have some updated numbers for you. Since 2015, there have been approximately 468 minors who have gotten married in the state of Maryland. Prior to that, the numbers I had from 2010 to 2015 were in the 3,000 range. But one thing that this bill does do is say that if you are emancipated, you cannot marry someone that is more than 4 years older than you. And with that,
Right.
The chair is looking at me.
Yes.
I love you all. Please pass my bill again.
Thank you very much. We're going to hear now from the panel. We'll hear from Alexander Goyette, Scott Poyer, Sasha Taylor, Charles Cuneo. Those are the people who have signed up in favor of the bill. We'll then switch to the unfavorable panel. So we'll take questions after we have the favorable panel. So if we have Alexander Goyette, please.
Thank you, Chair Clippinger and members of the committee. I'm Alex Goyette with the Tahirih Justice Center, speaking in support of HB 83. Tahirih is a national organization with an office in Baltimore that serves survivors of forced marriage, domestic violence, and human trafficking. We've worked on hundreds of forced marriage cases, including many here in Maryland. This bill, which makes a limited exception for court-emancipated 17-year-olds, is a strong step in the right direction. It also represents 7 years of thoughtful dialogue and bipartisan compromise. Becoming a legal adult makes a critical difference to one's ability to protect themselves, and HB 83 incorporates best practices tying emancipation to the minimum marriage age. Among the bill's key features are the appointment of counsel, background checks, a residency requirement, a waiting period between emancipation and marriage, and eliminating the harmful parental consent and pregnancy exceptions from current law. While Tahirih believes that setting the marriage age at 18 without exceptions is the best way to protect children, we're not here to let perfect be the enemy of the good. I thank Chair Atterbury for bringing the measure forward and ask the committee for a favorable report without amendments.
Thank you very much. Let's go now to Scott Poyer, the clerk for Anne Arundel County, who will speak for a minute. Clerk Poyer.
Thank you, Chairman Clippinger and members of the committee for this opportunity to testify. For the record, my name is Scott Poyer, clerk of the Circuit Court for Anne Arundel County. I am here representing myself as the elected official who's responsible for issuing marriage licenses and performing marriage ceremonies in Anne Arundel County. I am in favor of HB 83 because I do not feel the current laws provide enough protection for minors who may find themselves being pressured into marriage. I believe there's a lack of safeguards for minors under the current system. Under current law, only one applicant needs to appear to make the marriage application and swear that the information for both parties is correct. And the marriage ceremony itself can be performed by virtually anyone. Anyone can be ordained to perform weddings in Maryland. It takes about 5 minutes and costs $29.99 to fill out the online form and be ordained. The bottom line is we may never see the minor being married, and all we have is a green piece of paper that gets returned to us notifying us that the marriage has taken place. The applicant gets a valid Maryland marriage license recognized in all 50 states. If such a wedding took place fraudulently or under duress, it is especially bad for the minor because they would not be able to challenge the marriage until they turned 18. I think it is worth building in some extra safeguards into the system to prevent minors from marrying against their will, and that's why I support this bill. Thank you very much for the opportunity to testify.
Thank you very much, Clerk Poyer. We'll go now to Sasha Taylor, please, for 1 minute.
Good afternoon. My name is Sasha Taylor. I'm a U.S. citizen, victim of a forced marriage when I was in Arizona in 1991. Though this happened back then, it can happen anytime, anywhere, in any state that allows child marriage. I was forcefully engaged to a man who was 7 years older than me. I had never met or seen him before. A few months later, this individual's student visa was expiring and the families agreed to marry us legally in a local court. I didn't know who filled out my paperwork. Everyone was waiting for us to be called in front of a judge. I just walked up and repeated what I was told to say. I was not able to speak up, and no child is able to speak up for themselves when these atrocities are occurring to them, especially because government employees don't question what is happening, and these laws are legal in the states in which child marriage is allowed. Family pressure, abuse, and socioeconomic background are common factors among child marriage survivors. Archaic laws create these toxic cycles. I did not experience high school like a child should, and these laws that allow this to exist should not even be allowed in today's day and age, and they only benefit those that seek to exploit these children. Please I am urging you to change this law so adverse experiences faced by minors in the state of Maryland can finally be acknowledged.
Thank you very much. We'll go now to Charles Cuneo, please, or Cuneo.
Thank you, Chair Clevenger and members of the committee. For the record, my name is Charles Cuneo, and I'm a physician and assistant professor of pediatrics at Johns Hopkins University. I'm here today officially on behalf of the Maryland chapter of the American Academy of Pediatrics. The MDAAP is in support of HB 83 because it provides critical protections to help close loopholes in current state law, which will continue to leave children vulnerable to exploitation and abuse under the guise of child marriage if not addressed. Furthermore, we know from peer-reviewed research that child marriage itself can be harmful. As pediatricians, my colleagues and I see firsthand the devastating consequences of child marriage. It is one thing to read the statistics on the many adverse health outcomes for individuals affected by child marriage. It is quite another to disclose a new HIV diagnosis to a girl married to a man twice her age, or to have to ask for consent to provide medical treatment for a teen from her decades older husband. Passing HB 83 would represent a major step forward in protecting the safety and health of children in Maryland, one which is long overdue. A favorable report is requested. Thank you for your time.
All right, we'll take questions for the panel. We'll go now to Delegate McComas, please.
Thank you, Mr. Chair. Just briefly, I'm just wondering if it would behoove, besides maybe a certificate of emancipation, because you don't know how that happened necessarily, that perhaps that 17 is kind of young to get married too. And I know there's all kinds of different circumstances, and kids are, there may be this love at first sight and everything, but I'm wondering if that the person that is younger, that is still a minor, that they're not 18 or maybe even 21, that both people have to appear at the clerk's office to get the license. And then if there's an age difference of, and they're still, they're young, let's say 17, 18, and the other guy is like, let's say, quite a bit older, that the younger person is kind of like sort of advised or has to talk to somebody at that office just to see if everything's okay, separated from the person that they're getting married to. Just wondering if you think that would be a good idea.
Respond, Mr. Chair. Thank you. So thank you, Delegate McComas, for your question. So in this legislation, information is provided to the minor child, referring them to legal aid services, providing them information on human trafficking and domestic violence. But most significantly, in this legislation, the judge has to do an in-camera interview of the minor child by him or herself, without the parent or without the intended spouse, to determine if there's any coercion or if there's any position of authority being taken over that individual. The judge also has to conduct an evidentiary hearing of the parties and make specific written findings that none of that is occurring as well, and that it is in the best interest of the minor child to, in fact, get married. So those protections are in this bill. And again, if you are emancipated at 17, you wouldn't be, under this legislation, be permitted to marry anyone that is 4 years older than you. So that's 24, 21.
Okay, we'll go now to Delegate Juanita Fisher, please.
Thank you, Mr. Chair. Thank you, Madam Chair, for being here. It's so good to see you and for all your hard work on this piece of legislation. I wanted to thank Ms. Taylor for your courage to come testify and tell us your story. Madam Chair, you might be the best person to answer this. The language is not different from what we saw last year. And then what happened with the bill legislatively with the committee or the process last year? If you could cap that for us, what happened here and what happened in the Senate, please.
Thank you. Great to see you too, as always. The vote here in committee was, well, in your committee, I can't say here anymore, but the vote in committee was 12-6. And in the House chamber, it was 97-38. When it went over to the Senate, as in years past, they see fit that 16-year-olds should still be married. And we never got to a point with COVID and policing, we never got to a conference committee last year. They had their hearing yesterday. It's my understanding that one of the senators is going to offer an amendment of 16 and a half. I am adamantly opposed, quite frankly, to 16. I agree with Delegate McComas. 17 is too low, in my opinion. This 17 was an extreme compromise after years of working on this. This is actually, there's bipartisan language in here. We worked with some of the senators that are across the aisle from me in JPR. That language is in this bill. So this bill is a compromise bill, and I believe it has enough protections for a 17-year-old that their, well-being wouldn't be in jeopardy.
All right. Well, here, I saw Delegate Anderson's hand. He's lowered his hand. Delegate Anderson, did you still have a question or no? You're muted.
Yeah, well, I think Madam Chair answered my question, because
Okay.
I'm one of the ones who's still in support of there being a bright line at 18 years old. And I kind of wanted to ask the clerk of Anne Arundel County what his opinion was on that.
Go ahead.
Thank you for the question, Delegate. I'm of the same opinion as I believe Mr. Goyette testified. Not letting perfect be the enemy of better. I would also like to see bright line at 18, but if this raises it from where it is today at 15, I am in favor. So I think Delegate Atterbury's bill definitely is a step in the right direction, sir.
Thank you.
Thank you very much. Delegate McComas.
I apologize. A real quick question. Do you all have, and maybe this is to the Delegate Atterbury, but do you think that the judges are going to be able to be perceptive enough with these in-camera interviews, whether the child is under coercion or threat, or there's, or something nefarious going on? In other words, because we're putting a lot of burden on the judiciary here to basically ferret out what the problem is, if there is a problem. I don't know. I mean, I'm just wondering, how, because I know the judges are, they're very, very busy. So, but this is going to take some time and some critical analysis. And do they really have the training to do that?
I think that this would be, thank you for your question, Delegate McComas, that our family law judges do have the training and I think the experience to do these, and our judges who interact with juveniles. So I do think that this is a step in the right direction. Actually, some years ago, it was during my first term, which is how long this has been going on, I was asked to come down to Anne Arundel County, where I spoke to judges there and magistrates that work with juveniles and in family law, and other individuals there in the court. And they quite frankly were wondering, what should they do if a minor wants to escape a marriage and get divorced? They said, what should we do? Because legally you're a minor. You cannot file a petition for a divorce. So you can't escape a bad situation. So I think some judges, I believe, and prosecutors are already aware that this is an issue. And, I think this is the best way moving forward to try to stop it here in the state of Maryland.
Delegate Bartlett.
Thank you, Mr. Chair. Good to see you, Madam Chair. This question is either for you, Madam Chair, or Ms. Taylor, I believe. She spoke, and I was looking at some testimony here from the, I can't see it right now, but oh, yeah. So the question is on the economic impact. How does the economic impact come into play for low income individuals when it is actually, the minor doesn't have any money? So what is the economic impact that results from a child marrying someone, as the law stands now? What is the economic impact there?
I will
Taylor.
happily.
Yeah, go ahead, Ms. Taylor.
So
Go ahead, Ms. Taylor.
I will happily share my story. So for me personally, the economic impact was that my father was very abusive in the household. And my father was abusive to myself and my mother. And it was this cycle of abuse that continued. And this other family that came along who seemed to have more money. And in order to get me out of that household, the best way they saw was to get me out of the house and just to get me married off. Nobody asked me nothing. I mean, I got off the school bus. I was a sophomore in high school. I got off the school bus. And that night I was told, come over, there's a dinner party. And they just, after dinner, I was told to sit in the middle of a chair. And this woman walks up, places a gold chain around my neck, and congratulations, I'm engaged. And it turned out the person that they got me engaged to was here on a student visa. His family could not sponsor his family visa. So I was used with my US citizenship to sponsor this individual's visa. And then a few months later, we went into the courthouse and the entire family was there, had the legal wedding done. And then I was with my family, he was with his family. And then again, he became my legal guardian. I kept fighting it that I didn't want it. But then there was that honor abuse that I could not get out of this marriage legally. And even I still remember walking into a lawyer's office asking to get out. And he's like, I'm sorry, I can't do anything to help you. And the economic impact comes in from this cycle of abuse over and over. And then on top of it, you have right away when girls are forced into this child marriage, they have children right away. So it continues and continues.
I can just quickly add, Mr. Chair, just in terms of statistics, and thank you, Ms. Taylor, for sharing your story, that the majority of child brides are young girls who are from poverty. They're likely to drop out of school, which will continue the cycle of poverty. 31% of young girls who marry stay in poverty. Their earning potential and work opportunities are limited because of their low education. They're 50% more likely to drop out of high school and 4 times less likely to graduate from college.
Mr. Chair, if I may. So what I'm hearing is the problem is twofold. It can be almost a form of, I hate to use the word as strong as trafficking, but it can be used almost in a trafficking for the economic benefit in that regard, but also it can perpetuate the cycle of low income and families and poverty. Am I understanding that correctly?
Yes, thank you, Delegate Bartlett. That's exactly right. And in years past, I did not reach out to them this year, but in years past, the Archdiocese of Baltimore actually supported this legislation because of the human trafficking ties to child marriage.
Thank you, Mr. Chair.
Thank you. Seeing no further questions for those in favor, we thank you all very much for being here. We're going to go now to the panel opposed to the legislation. That is Michelle Hanash, Aliyah Abbas, and Vince McAvoy. Michelle Hanash. We'll try again. They might just be entering the Zoom.
Yes, I just entered. Thank you so much.
That's fine. You have a minute. Go right ahead.
Thank you for allowing me this opportunity to testify. I'm the Director of Policy and Advocacy at Unchained at Last, a survivor-led nonprofit working to end forced and child marriage in Maryland and across the U.S. through crucial direct services and advocacy. States across the U.S. are moving to end child marriage. Many of them are Maryland's neighbors. They've already done so. Delaware, New Jersey, Pennsylvania, most recently Rhode Island and New York have all ended child marriage below 18 without exceptions. And legislation to do so is currently pending in Vermont, Massachusetts, and multiple other states. But with HB 83, Maryland, instead of joining its neighbors and actually the rest of the world, is clinging to child marriage, contrary to common sense and all available research on the harms of child marriage. Even at 17, child marriage is a human rights abuse, as you've heard, destroys every aspect of a girl's life, and it's easily forced. And 63% of the children who are married in Maryland are age 17. So you cannot end this human rights abuse by failing to protect 63% of those impacted. HB 83 includes pages of so-called safeguards. They acknowledge the terrible dangers of child marriage, but cannot mitigate it or prevent it. Emancipation, for example, upon approval of the marriage petition, gives some rights of adulthood too late, only simultaneously with the marriage petition being approved. And the idea that a minor could escape in 15 days before being married off and raped is absurd. There's also no way for a court to prevent coercion. As you know, children who are forced to marry are forced to lie. Oh, yes.
You need to begin to wrap up, please.
Thank you. I will just say that no survivor we've ever worked with ever was able to notify the court because they were too scared. So I would ask you to reject HB 83 and instead pass simple, common sense legislation to end all child marriage before 18. No exception, no gimmicks. Do not compromise on the lives of girls in Maryland.
Thank you very much.
Thank you.
Go to Aliyah Abbas, please. Ms. Abbas.
Yes, hi. Thank you, Chair. Thank you to all of the committee members. Thank you, Vice Chair. I'm going to make this really, really quickly. So my name is Aliyah Abbas, and I'm a survivor of child marriage. And also I advocate for the bright line of 18, no exceptions. So nearly 3,500 minors were married in Maryland from 2000 to 2018, of which 63% of them were 17-year-olds like me, including myself. Let me quickly pull this up. Yes, this bill is introduced as a compromise, but I say no to compromises on the lives of children. We are speaking of majority of the child bride cases are of 17-year-olds. They are at a higher risk. So if this bill passes, we are leaving out majority of the population. And this, I'm really scared that if this bill passes, we're just going to get very, very comfortable, and we're not going to be able to pass the 18 no exceptions. It's a shame that we here in the greatest country, built on freedom, liberty, and justice for all, we cannot pass a bright line of 18 bill to protect all children. Yes, sir.
And to wrap up, please.
Okay. Emancipation to marry itself is a loophole for 17-year-olds to be coerced into marriage. Parameters does not guarantee the non-use of parental coercion. So please, I urge everybody to vote no so we can pass the bright line of 18. I would love to have that introduced, and we need to just get on board with that. Thank you so much for your time.
Thank you very much.
Yes.
Vince McAvoy now, please, for 1 minute.
All right, thank you so much, Chair and Committee, for listening. I heard this over in the Senate yesterday, and when the sponsor gave a surprisingly small number of people this involved. The sponsor today in the House brought up several different countries and several different counties, and I would offer that, I know people from Lebanon, Ireland, Russia, Italy. I've never heard of this. I don't even know of one case. And so we had a limited amount of cases that were listed by the sponsor. What I hear from the one in the House today, this is more an ideological jobs bill. How dare a woman choose home life and not a job? I also said yesterday, this is ineffective use of the judges. We just heard yesterday where everybody's saying the judges don't know their head from a hole in the ground. They need all this training, but they're supposed to look through all this on the fly for a marriage, which actually appellate courts already said, look, we really don't even have a horse in this race. But what should happen is the clerk should be looking at this and have, that's their job, okay? Make them stand up and say, look, this is fishy, we're gonna stop it. But what I see this is we're trying to stop people who are maybe with child, maybe not, who just want to get married at a young age.
Thank you, Mr. McAvoy.
Thank you, I'll wrap it up. If we want this at a young age, it should be an appropriate young age. It doesn't need to be 18. I thank you for your time.
Thank you very much. For their questions for the panel. Seeing none, we thank you very much, and that concludes the testimony for House Bill 83. We have Delegate Crutchfield and House Bill 153. It is 147. I understand there are two witnesses in particular who cannot testify after 2 o'clock today. So Delegate Crutchfield, we're going to hear from you for 2 minutes. We're going to hear next from Joe Riley and from Lisa Jordan. and then we're going to see where we are. We'll try and actually get through a full first panel, and then we'll go from there. But with that, Delegate Crutchfield, please.
And thank you, Mr. Chair. Good afternoon, Mr. Chair, Vice Chair Moon, and all my colleagues. First of all, this is an oldie but goodie. So for the record, I'm Delegate Charlotte Crutchfield from Montgomery County, representing District 19, and I'm here to testify briefly on HB 153. And this is the legislation to repeal what's known as the spousal defense. What that does is right now provides a shield to married individuals who commit sexual acts against their spouse. And what we're attempting to do here with this legislation is to totally repeal that. This has come before the committee several times. In fact, it was voted out of the House of Delegates twice in session 2020 and in session 2021. So again, I am here, colleagues, to request a favorable report on HB 153, and I'd like to turn it over to my panel.
We have just heard the bells here in the House Office building, so we're going to ask people to be succinct. We'll hear from Lisa Jordan, and we'll hear from Joe Riley, and then we'll take questions, and then we're going to hear from the rest of the witnesses after we come back from the floor. Lisa Jordan for 1 minute, please.
Thank you, Mr. Chair, Mr. Vice Chair. I'm Lisa Jordan at the Maryland Coalition Against Sexual Assault. We're here to urge a favorable report on House Bill 153. Thank you for passing this bill last session. It is a matter of principle, and it's also important in reality. Spousal defense laws are archaic. It was 1736 that Sir Matthew Hale explained that marriage constituted permanent consent and could not be retracted. This belief should be rejected. This is not just principle. An advocate shared the story of a woman who gave birth after a C-section, very difficult labor. She had wounds and stitches in intimate areas, newly home from the hospital, and in pain. She told the child's father she was in pain, could not be touched. He touched her anyway. Under Maryland's current law, if they are unmarried, this is fourth-degree sex offense, as it should be. But if they are married, marriage is a complete defense to that crime. Last session, the Senate had some amendments that would have corrected these disparities between married and unmarried couples by diminishing the rights of unmarried people in sexual relationships. This is the wrong way to go. All competent adults should have the right to refuse sexual interactions, including sexual touching. The spousal defense law is wrong. It's past time to change it. And CASA, again, thanks the committee for its past support and urges a favorable report on House Bill 153.
Thank you. Joe Riley, please.
Thank you, Chairman Clippinger, Vice Chair Moon, members of the committee. My name is Joe Riley. I'm the elected state's attorney for Caroline County and the legislative chair for the Maryland States Attorneys Association. It is my pleasure to be testifying in favor of a bill with Delegate Crutchfield. We are seeking a full repeal of the so-called spousal defense for third-degree sex offense and fourth-degree sex offense. It is arcane. It is a vestige of a time that is best left in the past. For those of you who might think there might be an oncoming onslaught of people filing charges because they're in contested family matters, please read the law. Currently, if you are in a separation, you can file this and don't have to worry about the spousal defense. So it's kind of backwards. And being on the front lines of this, if this was really a true fear, you would see people filing second-degree assault, because people remember that second-degree assault, even though it's a 10-year offense, is a lesser included of fourth-degree sex offense, which is a 1-year offense, and there is no spousal defense for that. I don't see that happening, and I'm on the front lines of this every day in our courts. And so please pass this law, get rid of this defense, and stand up for spouses who may be the victims of third-degree and fourth-degree sex offense.
Thank you very much. We're going to go to Carrie Williams from the Office of the Attorney General, as she also has a conflict for later on today. Carrie Williams, please, for a minute.
Thank you so much, and thank you for taking the time to hear my testimony. Good afternoon, Chair Clippinger and members of the committee. The Attorney General urges a favorable report for House Bill 153. Prosecutors have been able to bring sexual assault charges against people in committed but unmarried relationships for decades, yet we do not see prosecutions based on a lack of affirmative consent or the kind of familiar, intimate touching that drives the parade of horribles put forward by opponents of this bill. That's because the law does not allow these prosecutions, as I detail in my written testimony. When a victim is conscious and competent, mere passivity is not enough to prove lack of consent. Marriage should not operate as a defense to sexual assault. The Attorney General urges a favorable report on House Bill 153. Thank you.
All right. We thank you all very much for your very rapid testimony. It's 153. Here's how we're going to do this. Delegate Crutchfield obviously will be back with us after we come back for the floor. We're going to let her take questions to her here afterwards. Does anyone have any questions for either State's Attorney Riley, for Lisa Jordan, or for Carrie Williams? Seeing none, that's fine. We're going to stop right here. When we come back, it'll be Ashley Inderfirth, Michelle Siri, Gina Cirincion, Dorothy Lenig, Michelle Smith, and Melanie Shapiro, and I think Jeremiah Pope, but I think Jeremiah Pope signed up for Delegate Crutchfield, so not Jeremiah Pope. Okay, so we will hear all of them in the next panel. It is, again, 1:53. The bells have rung here at the House of Delegates. We have to go back to the floor. We're going to conclude this first portion of the Judiciary Committee's bill hearings. Members will be returned to the House chamber for floor session. When we close the Zoom, this current live stream will end. However, 15 minutes after the conclusion of the floor session, we will return to conclude this bill hearing and the remaining bill hearings we will hear today. Members and witnesses who have been in our Zoom waiting room use the same Zoom link that is in your possession to access this meeting when it's time to resume. We'll keep the public updated with our committee hearing time on our hearing schedule found on the Maryland General Assembly website, and you can watch us on the floor also with the Maryland General Assembly website, so you'd have a sense of where we are with that debate. If anyone has any questions, you can please contact the House Judiciary Committee at 410-841-3488. That is 410-841-3488. And now with all of those public service messages done, thank you all very much. This concludes this part of bill hearings for today on January the 27th. We